Today, I want to talk to you all about sovereign immunity. Sovereign immunity is an ancient monarchical concept that viewed the king as owner of all property, including the life, liberty, and possessions of all their subjects, with power to harm them without recourse. It's based on the doctrine that the king can do no wrong, the king could not be sued in his court. Now, I previously talked to you all about the social contract according to Jean Jacques Rousseau. According to Jean Jacques Rousseau, the sovereign is the owner of all property and the owner of the subject. So this is the reason why reparations is impossible without sovereignty. The sovereign owns you. So I mean, there's a religious implication behind this also because the idea was that the king was put in power by God, so therefore the king was acting on behalf of God. So that's the reason why you can't sue the king, because to sue the king is to sue God. So it really has no place in modern society because you're basically saying you can't sue the state because the state is God. Um, yeah, there's a problem with that. So let's get into this article, and I'm breaking this up into sections because it may get a little bit long-winded, and I don't want to bore people with this. So I'm just going to break it up into sections. In recent years, the Supreme Court has substantially expanded the scope of state sovereign immunity. These decisions provide an important occasion for reconsideration of the entire doctrine of sovereign immunity. This article argues that sovereign immunity is an anachronistic concept derived from long discredited royal prerogatives and that it is inconsistent with basic principles of the American legal system. Sovereign immunity is justified neither by history nor, more importantly, by functional considerations. Sovereign immunity is inconsistent with fundamental constitutional requirements such as the supremacy of the Constitution and due process of law. This article concludes that sovereign immunity for government at all levels should be eliminated by the Supreme Court. I think there's a problem with that. The Supreme Court is not going to eliminate sovereign immunity. It has to be eliminated by Congress and ratified by the states, but the states are also not going to do that. This is the reason why I said we need a new social contract, that the entire system needs to be dismantled. We need a new contract, that the contract that was binding on past generations should not be binding on current generations. They don't have the right. Just because previous generations were ignorant or they were not able to foresee the problems that would emanate from this social contract, that we should not be bound by that. Sovereign immunity is an anachronistic relic, and the entire doctrine should be eliminated from American law. The principle of sovereign immunity is derived from English law, which assumed that the king can do no wrong. Since the time of Edward I, the Crown of England has not been suable unless it has specifically consented to the suit. Throughout American history, United States courts have applied this principle, although they often have admitted that its justification in this country is unclear. Let me read this footnote. As John Off pointed out to me, the phrase "the king can do no wrong" has many possible meanings. It might simply mean that when a wrong occurs, someone else must have done it because the king can do no wrong. Alternatively, it might mean that a remedy must exist because the king can do no wrong, as would occur if a harm went unremedied. A doctrine derived from the premise that the king can do no wrong deserves no place in American law. The United States was founded on a rejection of monarchy and royal prerogatives. American government is based on the fundamental recognition that the government and government officials can do wrong and must be held accountable. Sovereign immunity undermines that basic notion. The doctrine is inconsistent with the United States Constitution. Nowhere does the document mention or even imply that governments have complete immunity to sue. Now, before I read this article, I assumed that the 11th Amendment does give them immunity, but this article actually addresses that also, that the 11th Amendment only applies in a narrow circumstance. Yeah, it's this is not based on the Constitution. This is judicial fiat. Sovereign immunity is based on a common law principle borrowed from English common law. However, Article 6 of the Constitution states that the Constitution and laws made pursuant to them are the supreme law, and as such, it should prevail over government claims of sovereign immunity. Yet, sovereign immunity, a common law doctrine, trumps even the Constitution and bars suit for relief against government entities in violation of the Constitution and federal laws. Sovereign immunity is inconsistent with a central maxim of American government. No one, not even the government, is above the law. The effect of sovereign immunity is to place the government above the law and to ensure that some individuals who have suffered egregious harm will be unable to receive redress for their injuries. The judicial role of enforcing and upholding the Constitution is rendered illusory when the government has complete immunity to suit. I want y'all to let that sink in, because not only do they have immunity from judgment, they also have immunity from suit, which means that they can file a motion to dismiss and you don't even get discovery. They don't even have to justify it. And they'll say, like, so I told y'all before about the 3 levels of scrutiny: strict scrutiny, intermediate scrutiny, and rational basis, right? So you would like to know, you would like to get an explanation for why the government did what it did so that you can plead your case, right? Because once they give you, once they respond to your discovery, then you can file an amended complaint. But because they have immunity from suit, that includes immunity from discovery. So they don't even have to respond to your request. This is a problem. This is complete judicial fiat. Moreover, sovereign immunity undermines the basic principle announced in Marbury versus Madison, that the very essence of civil liberty certainly consists in the right of every individual to claim the protection of the laws wherever he receives an injury. I thought that they were going to cite the most well-known excerpt from Marbury versus Madison, which is, let me see if I can get this right without referring to notes. It is emphatically the province of the judiciary to say what the law is. I know I butchered that, but it's something like that. Y'all go look up Marbury versus Madison. That case established judicial review. All of this seems so unclear and obvious, yet sovereign immunity is not fading from American jurisprudence. Quite the contrary. The Supreme Court is dramatically expanding its scope. In Eldon versus Maine, the court held that sovereign immunity broadly protects state governments from being sued in state court without their consent, even to enforce local laws. Right. State and we'll get to qualified immunity a little bit later. In Seminole Tribe versus Florida, the state greatly limited the ability of Congress to authorize suits against state governments and to override sovereign immunity. The court applied this principle within the past couple of years to bar suits against states for patent infringement and for age discrimination. Although all of those cases involve suits against state governments, the court has indicated no willingness or likeliness of relaxing the sovereign immunity of the United States government. In this article, I argue this entire body of law is simply wrong, and that the doctrine of sovereign immunity should be banished from American law. No government, state or federal, should be accorded sovereign immunity in any court. Part 2 considers the constitutional status of sovereign immunity and makes 2 arguments. First, that sovereign immunity is not a doctrine based on the United States Constitution. And second, that sovereign immunity should be regarded as inconsistent with the Constitution. Part 3 then considers the policy justification for sovereign immunity and argues that it is an undesirable doctrine that undermines both government accountability and compensation for injured individuals. Part 2, I consider the primary justification for sovereign immunity protecting government treasury, separation of power, the lack of authority for suits against government entities, the existence of adequate alternatives to suit against a government interdiction, and I argue that none of these justify the doctrine. Obviously, I do not see the Supreme Court eliminating sovereign immunity anytime soon. Then I don't understand why he would preface his argument that the Supreme Court should be the one to abolish sovereign immunity. This would need to come from Congress. Well, they can't do it through the Constitution because states are never going to ratify it, but they would have to do it through the 14th Amendment. The trend unquestionably is in the opposite direction, yet I feel confident in the prediction that there is a time that the Supreme Court will abolish sovereign immunity. The doctrine conflicts with too many basic constitutional principles to survive. Um, I told y'all that I recently had a tree fall on my fence that was owned by the city, and I filed suit in small claims court because the damages are nominal, right? And they could just pay it, but they don't want to pay because they think they're above the law. So what they did is they filed a notice of removal to federal court because, well, I guess they believe that the justice court would probably rule in my favor because, you know, justices of the peace are not necessarily attorneys, right? They're it's more like akin to a court of equity, right? But they removed it to federal court because then they get to argue sovereign immunity. Sovereign immunity doesn't actually apply to municipalities. And I'm going to get into all that. I'm going to get into all that because the whole notion of sovereign immunity is that it's protecting the sovereign's treasury. So because a municipality is not part of the state treasury, they're not entitled to sovereign immunity. They did argue sovereign immunity, but no, it's not sovereign immunity, it's qualified immunity. So even they got that part wrong. But at the end of the day, it's a lot of work, it's a lot of research to try to wiggle and navigate through this complicated legal gobbledygook. It should not be this difficult. You damaged my fence, you should have to pay for it. Just because you're the government does not give you carte blanche to damage private property. So, God, and I think I live in a wrong district because, yeah, they're probably going to side with them. But it is what it is. I'm going to figure out a way to get my money from them. But I'm going to go ahead and end this because I want to break this up and I want y'all to really take this all in, what sovereign immunity means. And then I'll eventually come back to judicial immunity and how presidents are not the only ones who have absolute immunity, that it extends to all branches of government at the highest level. The governor of states, legislatures, judges, even at the municipal court level. So everyone's acting like there's something special about Trump. There's nothing special about what happened to Trump. But I don't want to get hit on myself because I do want to address that in a separate video. But for now, I'm going to go ahead and end this, and then I'll come back and address this in greater detail.